Look at that, we're all in our places.
Good morning.
Good morning. Good morning.
Morning.
The three smart ones are on video.
How was the driving up there?
It was not beautiful.
That's what I was afraid of.
Yeah, you definitely chose the path of least resistance. All right, shall we get started? Okay, welcome to the January 29th meeting of the Commission on Governmental Ethics and Election Practices. We'll get the meeting started with agenda item 1. It's ratification of the minutes of the December 18th, 2024 meeting. Would anybody like to make a motion?
I will.
And the motion is that we ratify the minutes?
Yes.
Great. Is there
I'll
a second?
second that. I'll second it.
Great. It's been moved and seconded that we ratify the December 18th, 2024 minutes. We should do a roll call vote. Commissioner Ahern,
Yay.
Commissioner Leclerc. You're muted, I think.
I'm going to abstain because I wasn't present for the meeting.
Okay. Commissioner Hastings,
Yes.
Commissioner Marble? Yes. And I'll also vote yes.
Oh, he's next. He's there, huh?
Yeah, how about that?
Yes, I couldn't see you.
That may be on purpose, we'll see. The diehards are here. Moving on to agenda item 2, it's a complaint alleging coordinated expenditures by the Maine Senate Republican PAC. Is there someone here to, please?
Mr. Chair, we also have someone on Zoom.
Okay,
That's the
terrific.
person about the complaint.
Okay, terrific. I don't see the person on
Oh,
Zoom.
she was there for a second.
Yeah,
Oh, great. Ma'am, the way we usually do this is we'll have Mr. Wayne tell us generally about the complaint. Then we'll give you a chance to explain what's going on. We'll give anybody else who's here to represent themselves a chance to discuss it. And then we'll discuss it, make a decision. So Mr. Wayne.
Sure. At the October 30th meeting, in response to a complaint, the commission directed the staff to do an investigation into a mailing that took place in mid-October. The Maine Senate Republicans PAC sent a postcard mailing in support of the Republican nominee for state Senate, Dick Bradstreet. And the postcard contained an endorsement message from the outgoing state senator, who is Matt Pouliot. And so the complaint asked the commission to consider whether the cost of that postcard mailing was a in-kind contribution to Dick Bradstreet, because the PAC might have cooperated or consulted on the postcard with Matt Pouliot, who was Senator Bradstreet's campaign treasurer. And the gist of the complaint was, isn't this coordinating with an agent of Dick Bradstreet? Shouldn't this be viewed as a contribution to his campaign? So I interviewed, along with Heidi Heffler, the PAC consultant who organized the mailing, and the PAC was entirely cooperative with the investigation. I also interviewed the PAC treasurer, but the consultant said that he approached Matt Pouliot about providing a statement for the mailing. There was a text back and forth, but at the time he did that, he was not aware that Matt Pouliot was the candidate's treasurer. So the cause of this, as I understand it, is just a factual mistake. They didn't know, the PAC didn't know that they were consulting with someone who was the candidate's treasurer. So we advised the consultant advised the treasurer, please file an independent expense report, because he viewed it as an independent expenditure. She filed an independent expenditure report, and the mailing went out. When I interviewed Dick Bradstreet, he said he didn't know about the mailing at all. He had no advanced knowledge. He didn't consult with the PAC at all about it. He found out about the mailing when he got the postcard. So staff recognizes that different people may want to apply the statutes differently. We offered a tentative recommendation in our memo that the PAC made a a material false statement in the IE report. We don't believe it was intentional. We think the treasurer thought it was truthful at the time, but we think it was false and materially false. So whenever the commission is ready to act on the complaint, at this point, our recommendation would be a couple of findings of violation and a $1,000 penalty. And I should say, I haven't had a chance to talk to the PAC yet about their point of view on our recommendation or, how the law to be applied. So this is all, from my point of view, somewhat tentative.
Okay.
Thank you.
I have a kind of an initial question, and for you and for Mr. Bolton. With respect to the false statement, issue, is it possible to make an unknowing, and not intentional false statement? Is there some mens rea requirement there? I mean, just the language says misrepresentation, and that kind of implies to me that there's some require of at least knowledge that this statement is false.
Are you referring to 1004?
-A5. It just at
Sorry,
first,
I'm just trying to find the
Sure.
statutory language.
sure, at first glance, or at first impression, it doesn't seem that it's possible to make a false statement without knowing that it's false or intending that it's a false statement. There must be some mens rea there.
I mean, I think, and this is it's the commission that ultimately interprets these statutes. I think, I mean, the statute could read, a knowing misrepresentation or a willful misrepresentation. It doesn't have the mens rea term that you would normally see, which, suggests to me that it's strict liability. That if you make a statement and it's false, even if it's unintentional, it could still be a misrepresentation. That would be my take on it, without some modifying language that says knowing or willful or something like that.
Okay.
But again, I think it's ultimately the commission's call how they interpret their statutes.
Okay, good.
I think, even if you have the discretion to find the violation, if it doesn't feel right.
Yeah, sure.
A lot of times different commissioners I've had the pleasure of working with want to see a degree of fault. And if they don't see that degree of fault, they don't want to take the action.
Sure.
So, and that might be appropriate here.
Sure.
This might not be the right finding.
Okay,
Yeah.
great. Ms. Perry? Oh, yeah, Commissioner Hastings.
I'm wondering if we should consider applying a standard of the person knowing or should have known that the statement was false. I have some sympathy for somebody that makes a totally unknowing false statement. But if they should have known it was false, then I have less sympathy, and it's a different standard than intent, I guess, but and in this case, I wonder if, considering that it was the party PAC, perhaps they should have known of the relationship of prior senator with the new campaign.
Sure, that's an excellent point.
I really appreciate that addition, because that does not mean it's a mens rea. So thank you, Commissioner Hastings.
Okay, Ms. Perry, I'm sorry to take a while to get to you. Could you introduce yourself and describe your complaint?
Sure. Thank you. My name is Whitney Parrish Perry. I'm a resident of Augusta, so I'm a voter in this district, and I did file the complaint, I believe, it's in October, so about a week before the election. And I received this postcard as well to my residents, just me, not my husband. And it just didn't sit right with me. I am from Chelsea, so right next door, and have known former Senator Pouliot for some time. We actually worked at Sears together when we were like 18, back when Sears existed. And so we do know each other. And I say that because he's a very well-known person in Augusta and a very well-known person in Maine politics. And while I really sincerely appreciate this discussion and the work done by staff to look into the complaint, I was a little disappointed by the recommendation. Um, Ignorance of the rules doesn't necessarily give a pass and feels like it's punishing campaigns that do take the time to follow the rules. And I don't think that's what the commission is trying to say, but that is kind of an effect that lands with me. At the October 30th meeting, there was a candidate who was fined for a 1 day late report. And Mr. Wayne did explain to the committee that there are often good faith and intentional reasons why that may happen, but that there's usually a recommendation that a penalty be assessed, because the candidate and the treasurer need to follow through the process. And I think at one point someone said that they hoped the treasurer would help Mr. Sear pay for the fine because they felt it was the treasurer's fault, not the candidate's. To me, that indicates that the treasurer does have some responsibilities to follow the rules, and claiming ignorance in the situation doesn't work. Further, these, duties and responsibilities come with the roles. And so it was also mentioned that the Maine Senate Republican PAC had no knowledge. I think the consultant that Mr. Pouliot was the treasurer, except former Senator Pouliot's name is on every piece of literature paid for by the campaign and every sign that goes up. So, ignorance on the part of the PAC can't be an excuse either. This is well-known information. So I won't meander, but the mailer was a contribution to the success of the campaign against an opponent. And I would argue that a report filed late doesn't have that same impact on an election. And pleading ignorance doesn't make sense to me in this situation. So at the very least, I think, the PAC paying for the mailer makes sense to me. I think it was $2,920.05. And as well, the campaign could have disclosed as well. And the cost of that mailer, it just makes sense to me to receive the same penalty. While I understand that Senator Bradstreet claims no knowledge, at the very least, I think that the optics of the situation should be concerning. And so thank you for indulging me. I appreciate your time, wading through this. I know it's been a few months now, and it came at a very busy time. So thank you.
Well, thank you for your statement. I really appreciate it. Mr. Tardy.
Good morning, Commissioners. Joshua Tardy here on behalf of the PAC. Struggled with the same sort of analysis that you did, Mr. Chair, on sort of a mens rea. And just from a big picture, I am, as an attorney, comforted by the fact that if there's a violation here, it's on a PAC and no individual. And I think that's important because none of the humans in here did anything with any type of intentionality. I do accept that this is a tough one to size up to a violation. And but I mean, from a pragmatic viewpoint, do think that if you make an independent expenditure and you have inadvertently or however as in this case, use the treasurer's endorsement, that it's got to be something. Okay, and there should be some type of violation under Maine's campaign finance laws. I don't. This is one of those cases where we could argue materiality, we could argue mens rea. I actually think there's a common sense interpretation, as suggested by counsel for the commission, that or somebody suggested knew or should have known. I think that kind of makes sense. There should be clarification on that. But that said, you know, the facts are the facts here. You don't need to meander. Okay, Senator Bradstreet had no knowledge. He's completely, you know, not part of this. The impact on the election is the mailer was going to go out. The matter of who pays for it. You know, Matt Pouliot does have a right to endorse whomever he wants, in that, and there was no surprise who is endorsing in this race. And the fact is, the PAC has participated fully and full cooperation with the staff in this investigation. With respect to the second violation, I've argued this unsuccessfully before, and you may recall there was a illegal contribution violation that the PAC, that this commission considered back in a special election that involved candidate Bill Jarrett. And it had to do with the use of the value of a DOT or an electric sign. And I argued then that it shouldn't be considered a contribution. The contribution was something that should be an offer and acceptance. To me, this feels like finding the second violation is sort of the equivalent of citing somebody for running a stop sign and failure to yield. But that said, the monetary penalty, I think, is reflective of the action. We don't oppose the staff's recommendation, and I had the same struggles trying to fit what the violation should be.
Great, thank you very much. Are there questions or comments from commissioners?
Just briefly, I don't feel comfortable imposing some sort of mens rea where it doesn't exist in the language. I mean, we are talking about entities that are specialized in the field of campaign finance and campaigns. So I don't think it requires any sort of knowing violation. There's a duty to assure that you're making correct statements, I guess, imposed by this particular statute, 1004A5.
Well, you're kind of echoing what Commissioner Hastings said, is that you're adopting the should have known.
Yes. Yeah.
Yes.
I just wanted to highlight something that I should have in your initial response, but in the second paragraph of 5, there is the level of intent to mislead is specifically a factor in determining. So I get this language exactly right. In determining any penalty is one of the factors that the commission shall consider.
Okay, great.
So I think that gives you wide discretion there, but it does specifically say you should be thinking about that when you think about
what provision are you referring to?
It's 1004-A5, the second paragraph.
Okay, all right. And did the commission staff take that into account in making its recommendation, Mr. Wayne?
Yes, I mean, our thinking was the maximum penalty for making a material false statement is $5,000. we do this as unintentional, so we chose a penalty that was 20% of that maximum, but that's totally within the discretion of the commission, if you even want to go in that direction.
Are there other questions or comments from commissioners? Yes,
My only comment in general is what I've heard discussed and brought forward, to me, reinforces the staff recommendation. And that's the direction I'll be trying to head.
okay, so we really have two questions here. And I'll make a motion that we find that the Maine Senate Republican PAC violated 21A MRS 1015 paragraph 2B by making a contribution, and I will assess $1,000 fine. Is there a second?
I'll second that.
It's been moved and seconded that we find that they violated the statutes by making that contribution. Is there discussion? Okay, we'll take a vote. Commissioner Hearn? You're muted.
Sorry. Yes.
Commissioner Hastings?
Yes,
Commissioner Leclerc?
Yes.
Commissioner Marble?
Yes.
And I also vote yes. The second question is whether the PAC violated 21A MRS section 1004A5 by making a material false statement. And I'll move that that is true and that there's no fine assessed for that. Is there a second?
I'll second.
Is there discussion? And I just want to say that I'll vote for it, and I am convinced by Senator Hastings or Commissioner Hastings should have known standard. And I think that that probably applies in this case. So Commissioner Hearn,
Yes.
Commissioner Leclerc,
Yes.
Commissioner Hastings,
yes.
Commissioner Marble,
Yes.
and I also vote yes.
Can I just add that I really appreciate Josh Tardy's, I don't know, analysis of these things and his honesty with the commission. Just wanted to say,
We
give a
can.
shout out to Josh.
Yeah, you absolutely can, and I appreciate it too. I think, you know, it's really refreshing when somebody comes in and says, look, we made a mistake. We're willing to live up to it. And I think they should be commended for it. And thank you.
You know,
Ms.
his yield stop sign analysis, you know,
Perry.
know how applicable that was, but I appreciate it.
And Ms. Perry, thank you for attending and for helping us out with your statement. We really appreciate it.
Thank you.
Okay, moving on to item number 3, it's a request for penalty waiver from the Honorable Roger Albert. Mr. Wayne, is there anybody here to? Okay, great.
Representative Roger Albert was a candidate for the House in 2024. And during the last 13 days before an election, if a candidate makes an expenditure of $1,000 or more, they are required to file a report within 24 hours. And so during that 13-day period last year, Representative Albert made 2 expenditures for radio ads that exceeded that $1,000 threshold. We notified him that we believed he should have filed 2 24-hour reports on October 26th and 29th, but they weren't filed until November 21st when his treasurer was filling out the post-election report. He explains it's an honest mistake. He didn't intend to violate the law. And this is for the benefit of other candidates who are here. The commission often receives requests for waivers based on good faith mistakes. Maybe there was a misunderstanding of the law or miscommunication. And the commission often sympathizes, but still assesses some penalty just to reinforce that the filing requirements matter. So since 2018, the commission has tended to assess penalties in the range of 300 to 350. when candidates file a report late. So in this case, there were 2 reports late, so the staff was recommending 400, but it's in your discretion. Where to go.
Sure. Are there questions or comments from commissioners? Okay, Mr. Tardy.
No surprise, good morning, commissioners, we accept the staff's recommendation and just, the matter going forward, I'm fairly confident that this candidate is going to have, more resources, for assistance on filing going forward.
That's great, great. Okay, I'll move that we reduce the penalty to $400. And I just want to say editorially that these are the ones that really bug me the most, and it's because they're depriving the public of information that would be timely before the election, but is not timely this long after the election. And so these cases of missed reports in the last part of an election really bug me, because they're depriving the people of information they should have. So I move that we reduce the penalty to $400. Is there a second?
Second.
Is there discussion? Commissioner Hearn?
Oh, yes. I thought you were asking me if there was discussion.
Oh,
Yes, I vote
yeah.
yes.
In a way I was, but that's how'd you vote? Commissioner Leclerc?
Yes.
Commissioner Hastings?
Yes.
Commissioner Marble?
Yes.
And I'll also vote yes. And thank you, Mr. Carter. Agenda item 4 is a request for a penalty waiver from Stephen Bishop. Is there anybody here for this? Okay, great. Mr. Wayne?
So the facts have some similarities here. Mr. Bishop was a candidate for the House last year, and during that last 13 days before the election, he made an expenditure of $1,538 for mailing. So we notified him that should have filed a 24-hour report on October 29th, but it wasn't filed. The whole transaction wasn't disclosed until December 11th after the election. The preliminary penalty is $2,707, and he's seeking a waiver, and he explains that this was a mistake in communication between him and his treasurer, and it led to the treasurer not filing a report.
Great, thank you. Mr. Tardy?
Same position, commissioners, agree with the staff recommendation. I'd like to come up with some type of stop sign analogy for Commissioner Hearn, but I'll defer.
We need more metaphors.
Yeah.
Okay, I'll move that we reduce the penalty to $300. Is there a second?
Second.
Is there discussion? So we'll vote. Commissioner Hearn?
Yay.
Commissioner Leclerc?
Yes.
Commissioner Hastings?
Yes.
Commissioner Marvick?
Yes.
And I'll also vote yes. Agenda item 5 is a request for a penalty waiver from the Honorable Walter Runte. Is it Runte?
Runte.
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 Please come up to the table. You've seen us go through a few, so you know the routine. We'll give you a chance to address the commission. Mr. Wayne.
So Representative Brunke filed a campaign finance report after the election in December, and it disclosed that he had made a payment for a mailing on November 5th. And so our staff contacted him and said, when did you order and approve the mailing? And he replied that it was on October 24th. So the definition of an expenditure in campaign finance law doesn't just include when you make a payment, but it also includes making a promise or a contract or an agreement to pay for campaign services. So we are aware that a lot of candidates are not aware of this, of the way expenditure is defined. But our view in the past has been that consistently is that if a candidate enters into a debt and commits to making a campaign expense during that 13-day period, that's an expenditure that needs to be reported in a 24-hour report. And we engage in ongoing educational efforts in our guidebooks and our mailings, our filing schedule to try to get that information through, but it's not something everybody gets, at least the first time around. So we notified the representative that we viewed the 24-hour reports late and the preliminary penalty is $1,275. We're recommending a waiver of $300.
Great, thanks. Are there questions from commissioners? Okay, Mr. Runte.
Thank you, Mr. Chair. There's no dispute over the cascading events that happened here. I fully admit that I had misinterpreted what expenditures were defined as, and frankly have been reporting expenditures when made, not when committed in a lot of transactions. So when I put this one in and it was flagged as, I was informed that it should have been when it was committed to change the date, and that triggered the need for a 42-day filing. And then it was the refiling of the 42, then said I needed to do a 24. And now this is 42 days after. So I did request a waiver of the fine that was originally ordered. I appreciate something perhaps more lenient than what the final staff recommendation was, but you know, I fully acknowledge the error here, and certainly going forward, understand what needs to be done.
Very good. Thank you very much. Are there questions from commissioners? Questions or comments?
No.
Okay, I'll move that we reduce the penalty to $300. Is there a second?
I'll second.
Okay, is there discussion?
I just want to say that I considered abstaining from this because I consider Jerry a friend. Hi, Jerry. And, but because he's so gracious and acknowledged that, appreciates that the fine was reduced, I don't feel like I need to, but I just wanted to flag that Jerry, it wasn't, you know, you are a friend, so good to see you.
Terrific. Well, thank you. So it's been moved and seconded that the fine is reduced to $300. Commissioner Ahern,
Yay.
Commissioner Leclerc,
Yes.
Commissioner Hastings,
Yes.
Commissioner Marble. Yes. And I also vote yes. And thank you again for coming in. We really appreciate the chance to discuss. All right, agenda item 6 is a request for a penalty waiver from the Honorable Joseph Rafferty. Please feel free to come up. And I think you've seen the way we're conducting these hearings, so it won't be a surprise to hear from Mr. Wayne, and then you'll get a chance to discuss it with us.
Good morning and thank you, and yes, I have that.
Awesome. So, Mr. Wayne.
So the facts of this case are a little bit different. Senator Rafferty was running for re-election in 2024, and he decided to buy a large amount of services from Ericsson Communications Group for digital advertising. So he made a first payment to Ericsson on October 15th, and he paid $10,558. And our understanding is that 2 weeks later, on October 29th, there were some additional services that he approved with a value of $10,000. So the $10,000 payment, which he subsequently made, wasn't. I think the $10,000 payment wasn't made until after the election, and it also wasn't reported until after the election. And that's the reason that we're recommending some sort of penalty in this case, because it was a large amount of services, and we think the public ought to know about those services in advance. It's, you know, it's $20,000. So before the general election, I think this should have been disclosed. We may have a little bit of a disagreement with the campaign. Our view was that he should have filed a 24-hour report in that last 13-day period for the $10,000 in services. The candidate in his waiver request explained that he thinks it should have been reported in the 42-day pre-general report that he filed it on September 22nd, and I gather it should have been, the theory is it should have been amended as time went on. Regardless where the debt ought to have been reported, from our point of view, either the September 22nd report was not substantially complete and should be considered late, or the 24-hour report should have been filed. Either way, we're recommending a $300.
Okay, very good. Are there questions from commissioners? Questions or comments? Okay, Mr. Rafferty.
Thank you. I personally am here most because I'm sitting in front of an ethics commission, a committee. And to me, that's my integrity is being questioned. That's how I view it.
And that's not the case. And this, I'll tell you, the title of the commission is the Commission on Governmental Ethics and Election Practices. So
Thank you.
this question falls firmly within the election practices part of our work.
Maybe it's just who I am, but that's my mindset. But in any case, I know I failed to make a report. I didn't communicate well with my treasurer. There are two of us that have run my campaign. But this is we've been through 3 campaigns. I'll probably I'm sure that I didn't report that. We made that decision on the 29th of October. Looking back, I'm like, that probably wasn't money well spent, just a handful of days before the election, because I don't know if anyone saw it before the election, but that said, I failed to report it to my treasurer. She couldn't possibly have turned around and made a report without knowledge that I made that expenditure. Once I did make her aware of it, she included it in a later report. I didn't get notice that I was in violation until December 23rd. And I was in a panic. I was out of state visiting with my family and I made numerous attempts at trying to connect with people to see what was going on. But given the fact that it was Christmas break and so forth, I was sending emails and, unclear whether they were being received or acted on. A lot of the bounce back was where offices closed, that type of thing. So I was in a panic for a while, and this has left me very uneasy, to be honest with you. But I'm to blame for not reporting to my treasurer. In terms of making these verbal agreements, so to speak, I clearly state anyone I work with, we'll see how it goes. Because my money this campaign wasn't the same as it was the last couple of campaigns. It was a little bit different. So I said, we don't do anything without my okay, because I won't okay anything if I don't have the money. I don't, so I'm not gonna spend without having it. So that's where I stood on that. But again, it was my failure to communicate with my treasurer that created this mess. But in terms of an agreement, I'm not sure my conversation with that company is in fact a binding thing. That's why I'm still a little bit confused on that.
Thank you. And I'm sure that if you want to discuss it with Mr. Wayne after the meeting or something, I'm sure he can help to walk you through, and Mr. Bolton can be available too, to walk you through the legal requirements. And thank you for being here. Ma'am, are you the treasurer?
I am not. Kate Knox at Bernstein Shirt.
Oh.
I apologize. I'm here to help with, no, I look differently. Help with questions and provide moral support, but he clearly doesn't need my help, but I'm here just in case.
He did a tremendous job.
He did, yes.
Are there questions or comments from commissioners? Okay, I'll move that we reduce the penalty to $300. Is there a second?
I'll second.
Okay, it's been moved and seconded that we reduce the penalty to $300. Is there discussion? Yes, Commissioner Martin.
Just a comment, just in full transparency. I appreciate your interpretation of events in terms of how they made you feel. I love hearing the clarification about practices. This is not about character, integrity. I'm gonna vote in support of the measure, but I did make a note to myself, just looking at reductions from initial formulaic penalties to what the recommendations are, I would have been okay voting for 500, just because the preliminary penalty was significantly higher than some of the other folks we reduced down to 300. But that's not enough to make me vote against the motion.
Okay, great. Any other comments or questions from commissioners? Okay, we'll take a vote. Commissioner Ahern,
Yes.
Commissioner Leclerc,
Yes.
Commissioner Hastings,
Yes.
Commissioner Marble, yes, and I'll vote yes too. And thank you very much, and thank you for your straightforwardness and
Thank you.
for helping us through it.
Folks, have a good day.
Thank you. Will do.
Thanks.
Drive safely. On to agenda item 7. This is a complaint by Mr. Clardy about websites. And feel free to come forward. And if you'd like to come forward and sit at the witness table too, you can.
Sure. Sing me or?
Well, whoever's here to represent anybody on this question.
Go ahead, please.
Hello.
Joe,
Yes.
are you on?
Yeah, I guess I'm coming up next, man. I don't know how this thing works. I'm listening to some of these people right now.
I don't have the link. They didn't send me the fucking link.
They didn't? Yeah, I just got the link this morning. You have to call Julie, and she sent it to my computer. I'm looking at all these commissions.
Sorry about that.
That's all right.
Do we know who needs to link the link?
That is Mr. Boyd. He is on, he's just in his break room.
And that's for the next agenda item, right?
That is.
Yeah, not for this one. We've got everybody here we need to have here for this.
Yeah.
Okay, so this is an interesting complaint, and I'll ask Mr. Wayne to tell us about it.
Well, this is a complaint by Mr. Clardy about 130 websites that were promoting candidates who were running for election in 2024. And some of the websites were organized by the Maine Democratic Party to help promote their candidates. And those use sort of a common template. They have a similar URL that ends with mainecandidate.com. That's about 79 of the websites in the complaint. And then the other websites were organized by the candidates themselves, and therefore they vary a lot and they have different disclaimers on them. So Mr. Clardy, what he noticed was that he identified 54 websites that said that they were paid for by candidates. That was what the disclaimer said on the websites, but when he reviewed their financial reporting, they didn't report making any payments for the websites, and they didn't report receiving any in-kind contributions for the websites. So I don't need to speak for him, but one of the points is, if the website says paid for by the candidate, it should have been paid for by the, we should see some financial reporting of that. So we reached out to, well, actually the way I would break down the complaint is two of the main issues he's looking at is, are these disclaimers accurate and were they compliant with what they needed to be? And also, did the candidates, if someone other than the candidates paid for these website services, did the candidates receive in-kind contributions that they should have reported, and that might be that might violate the terms of the Maine Election Act program. So we reached out to the House Democratic Campaign Committee and the Senate Democratic Campaign Committee, and they explained the genesis of the mainecandidate.com platform and the costs, and I very much appreciate all the effort that went into their response. And they also acknowledged that the costs should have been better identified, and they're offering to restructure the platform so that all costs are reimbursed by candidates and that they're reported accurately. We offer, an analysis in the memo, which I can get into now. I don't know if I don't want to talk too long,
No, go ahead.
From our point of
It's a complex complaint,
it is.
and there are a lot of moving
Yeah,
parts.
I mean, the PAC's identified 3 different costs, I would say, that went into this mainecandidate.com website. From our point of view as staff, the Senate Democratic Campaign Committee has been paying $14.50 a month to a cloud hosting company called Linode. The Cox PACs are arguing that I think that these are not expenditures because different exceptions to what is an expenditure applies to those. But from our point of view as staff, we politely disagree. We think that those were expenditures by the Senate Democratic Campaign Committee, or at least the commission has the discretion to consider them as expenditures, and that therefore they should have been disclosed on the maincandidate.com website. We're sort of neutral on whether you want to make a finding of violation. I think this is a situation where this platform was set up in 2022, and maybe it should have been, people should have attended more closely to what the disclaimer said, and similar to some of the comments that were made to Josh Tardy, I always appreciate it when one of the caucuses comes forward and says, should have done better. And that's sort of the spirit in which I'm approaching PAC's response. We also examined the 12 websites that candidates had organized themselves. We looked at the disclaimers, all of them but one, we think were accurate. They said that the candidates paid for them, and the disclaimer said that they paid for them. There's one where there might be grounds for a finding of violation because there really is no statement of who paid for the website. In terms of the financial reporting of those 12 websites, some of the costs were reported in December after Mr. Clardy filed his complaint. Some of the reports omitted some costs that candidates had paid for out of their own pocket, because sometimes these hosting and domain registration fees, they come up once a year, and candidates are inactive, and so candidates pay them themselves. So the candidates were very cooperative with us, and they amended their campaign finance reports to include those costs. So overall, in keeping with our policy on sort of minor omissions that are amended, that are fixed through amendments, we don't recommend any action on those omissions.
Okay, thank you.
Thanks.
Are there questions or comments from commissioners? Okay, Mr. Clardy.
Thank you. First, I would like to actually apologize to Director Wayne for having dumped this in his lab. You have no idea how long I worked trying to condense it down to something that you could read in 3 or 4 pages. But you did accurately present most of where I was focused on my complaint. A couple of minor things. It was in operation before 2022 because I actually copied the darn thing in 2020 for my own campaign website. And I saw Adam Turner's website and was like, oh, that's cool. And within about a week or so, I had registered the maincandidate.org domain with notions of doing something very similar until I read Maine campaign finance law and realized that that would be a nightmare. And so I kind of had my eye on it ever since, wondering how did they pull it off? Which is why we're all here today, because when I saw the list of, oh, wow, they've got all their websites listed. I don't have to go looking for them. And I just, ran through the financial reports and spent a lot of time and a few ibuprofen condensing it down to this. And I apologize if that's an overly meandering explanation of what got us here. But it was really just idle curiosity and then being startled when I saw that some candidates are paying for websites and others have websites that say they're paying for them, but they don't. And the inconsistency caught my eye. If nobody had paid for the maincandidate.com website, I probably wouldn't have thought much of it, except for the disclaimer part. But the fact that some do and some don't, to me, undermines a portion of the claim that the costs are so minimal that it doesn't count as an expenditure from the candidate's point of view. Either it does or doesn't, but some candidates obviously were paying attention enough that it should. If they've amended their reports and figured out what that mysterious little credit card charge was that they forgot about, I'm cool with that. And now they're a little bit wiser. But one aspect I do want to mention briefly, And not that I want, not that I'm asking for major violations or anything like that, but just as educational going forward. The whole coordinated contribution definition in the election candidates guide, it says coordinated contributions are a no-no. And if you cooperate with something that could be considered independent expenditure, then that makes it a coordinated contribution, and you should not do that. I mean, I'm kind of paraphrasing the language, and please feel free to correct me if I'm paraphrasing wrong. But, you know, these are prospective legislators who are going to be writing laws. And when you're asked, you know, can you offer up some verbiage for your policies or stances, some pictures? That's coordinating. So it's a threshold that I think may need some clarification. You know, how did something like this would play into that? I don't have any good ideas for, you know, how better to explain that, but that was one of the underlying themes that I was thinking when I was, because of that's why I highlighted that there were a certain number of clean election candidates. And, you know, did they have coordinated expenditure instead of an independent expenditure, which would be a contribution? And the whole thing with Dick Bradstreet as item 2 kind of seemed to be sort of a reminder of how messy that can get. So just putting that out there. I know you guys also prefer doing education and making sure candidates understand before they make the mistake. So if anybody can come up with, you know, solid explanations to make sure that everybody is on the same page on stuff like this, might be an item for discussion later on, or for, you know, staff editing. So that's and I apologize that I didn't write out any detailed, typical me explanation of this, because honestly, I keep getting a headache every time I look at it. The second item is I am kind of confused about one state party and 2 PACs acting as if they're sort of one coordinated, you know, single entity for reporting purposes. I'm not sure, you know, I always thought PACs, you know, the caucus PACs were considered legally distinct from the party as far as, you know, limits on what they can spend money on and how they work together. I'm not sure about that. You guys are the experts on that. I was honestly, my initial expectation was going to trace back to one PAC had a great idea and ran with it. And it's like, well, the Senate Democratic Campaign Committee rented out a big office, furnished office with desks. Democratic Party decided that they'd have staff members come in, go collect pictures and personal items from the candidates and decorate each candidate's desk accordingly. And the House Democratic Committee, I don't know, you know, what their role in it was. I'm kind of picture them as the, you know, the good buddy that rides along in the back seat. But having three different groups that are part of this, which one was in charge, which one should have been paying attention to details, it's kind of an open question. Last significant thing or significant area is the disclaimer, and that's the part that really bothered me most. Because I've worked with quite a few candidates who they find themselves with people throwing mailers and palm cards up and they're saying, I'm voting against you because you know, this came out, you know, saying you're for this and you're for this and you're for this. And they're like, I didn't send that. I didn't authorize that. I didn't pay for that. That's not me. That's somebody else trying to endorse me and thinking that's going to help. And that experience has kind of driven my sense of why that disclaimer is important. Because if the party had misstated the candidate's position, you know, how do they prove that that wasn't them saying that? And the whole question of who's putting it out. So there should be some some structure to how they were putting the disclaimer out so that people would know who actually is operating the website, providing the campaign support. You know, the dollar amounts, they aren't big. I wasn't sure how big they would be. That was part of why I was focusing on the PAC level, because I work with web hosting, and those numbers can go up and down and accumulate up to a pretty healthy chunk. But as Commissioner Leclerc pointed out, these are three distinct political finance organizations with, I would hope, experienced folks running them, paying attention. There should have been somebody along the way taking a look and saying, hey, this disclaimer doesn't feel right. If this disclaimer had been on a time card that was being distributed to county party committees or, distributed however, and, it said that it was paid for and authorized by the candidate, but it was actually, just some other ones or whatever, that was put out by the party, it would have gotten more attention, I think, or I have that feeling. I could be wrong, because it's a website, people tend to think, oh, it's just a website, it's not a big deal, nobody looks at those. Well, I know the numbers. Yeah, you're right, very few people look at them. It's probably even lower than the number of people who read a mailer before they toss it in the trash. But some people still read it. It is still part of the law, and just making sure that these folks are paying attention to following the details of the laws that some of them helped write. So I know y'all will have your own priorities, and presumably there's being some reorganization and somebody's paying attention. I'm sure the ladies will explain what they're doing to correct it. But from the commission's perspective, I would hope that you would look at, if somebody's knuckles need wrapping for, you should have known better. The candidates may get a 6-inch ruler on the knuckles, but the PACs and the party should rate at least a 12 or 18-inch ruler in proportion. Darn, throwing metaphors out. Maybe I won't be as good as the yield or stop sign, but anyway, that's really the crux of it. The actual bare numbers, it's far less of a thing to me than the overall operating principle. And it seems like they set up a program, put it on autopilot, and forgot about it. And that can be dangerous.
Thank you very much. Are there questions or comments from commissioners for Mr. Clardy? Yes, Commissioner Leclerc.
Just briefly, I mean, it's an interesting issue. And I notice on page 11 of the commission's staff's response or position statement, Mr. Clardy, they suggest something along the lines of a disclaimer on such websites going forward. Website authorized by the candidate, hosting fees paid by the, in this case, Senate Democratic Campaign Committee with the address. I'm wondering if you find that ameliorate some of your concerns, if that was a recommendation going forward. Commission on page 14, staff also recommends in situations like this that candidates pay a small one-time fee, and they, guessing at $10 to $25. And I'm just wondering what your reaction is to remedies such as that going forward.
I think that those are in the best spirit going forward. The candidates that did report payments for the main candidates, Tom broke down to ones that reported paying either two $6 payments, $12 payment, or there were a few that were more than that. that were reported that I couldn't tell if that was just whatever the $6 or $12 cost was rolled into something bigger. So, yeah, the single fee, so it actually pops out in the candidate's mind and makes it a little more likely to get reported would make sense to me. The language for the disclaimer, that makes sense. That actually is what I would hope would be done going forward. The exact nature of that language, like, you know, authorized by the candidate, but operated by the Democratic Party. That's more apparent. It does still raise the question of with the clean election candidates, how that plays into it, because then we get into that whole coordinated expenditure issue. So it's and plus, before putting too much weight in my opinion as to what would be good language, I have an engineering type mind, so you know what I see as being a good clear disclaimer may not be the most clear to everybody else. Did I hopefully mostly answer your question?
Yes, I just wonder if Mr. Wayne could respond to the issue of how this, if this does impact the Maine clean election candidates in a different way. Or a more.
Well, sorry, Commissioner, I didn't mean to speak over you.
You didn't.
Our point of view is that if you were to divide the $14.50 monthly charge for hosting among the 79 candidates who had mainecandidate.com websites, it really doesn't amount to very much at all. We offered the calculation in the memo that for the whole election cycle is just $2. I mean, that we agree with the PACs, that's really very minimal. And we didn't want to see the candidates in any kind of a violation of that situation. The other thing I would mention from the candidate's point of view, and the PACs might want to elaborate on this, is that there are a lot of exceptions in the law for efforts by the parties that they're allowed to do special things. There's special exceptions that are applicable to the parties where they can provide services to the candidates. So if a candidate participated in the website, they might logically infer that there was some kind of expense involved, but you know, they might also make the inference, well, this, you know, party knows what they're doing, this is covered, you know, so they might not necessarily view this as they've received a contribution because they're aware that they can get these other services from the party.
Thank you.
Well, I just want to say, I think that's a dangerous road to go down, to say that there's some level of contribution to clean election candidates that doesn't merit attention. I mean, I think in this case, it's clear that the candidates really didn't have any culpability. I think that this was imposed on them by the PACs. But I would be hesitant to go down a road saying that there's some level of contribution to clean election candidates that doesn't merit notice.
Could I clarify?
Sure.
Yeah, I didn't mean to say, oh, the amount is so small, there's no contribution. If that was sort of implied, that's not where I'm coming from. It's more that I don't know if it rises to the level that the commission would want to take any kind of enforcement action against the candidates. That was what I was getting at.
Right. Yeah. And I'll say my two concerns with this, it's an interesting issue. My two main concerns are the obviously erroneous attribution on the websites and the contributions to criminal election candidates. So, and I tried to sign on to a couple of these websites. It looks like they've been taken down. Okay, and go ahead. I'll ask you. Please introduce yourself. And
Thank you. Thank you, Commissioner. Kate Knox at Bernstein Sherman, attorney for both the SDCC and the HDCC. And this is my colleague Lisa Brzezinski, who's been helping me. Happy to answer those questions. If I could first say thank you to commission staff. This came in November, maybe.
Yeah, I was not rushing it.
And we were overwhelmed by recounts, both caucuses were, and the staff was very generous in giving us extra time to try to uncover some of the stuff. Isn't, as somebody who is not tech savvy, very complicated to try to figure out how these things relate, what charges were where. So we did a ton of work to try to uncover exactly what payments were going to what for what thing, and you have it laid out here. But I didn't want to be remiss in thinking we did get a lot of extra time, and that was very much appreciated.
Well, we appreciate your cooperation with the staff. You know, a big issue like this would be a bear to track down without your help.
Of course, we're happy to do that. And we tried to sort of break the issues out into the three things that you saw, which was the $750 payments, which it sounds like staff is recommending because they weren't paid in 2024 to let go of. The staff time for the party, which is a big part of this. And then it feels like the crux of the issue that we're sort of getting at is this, the charge for that the SDCC had on its credit card, and then the disclaimer. So I think there is no question, I hope we've made clear in the memo that $14.50 a month charge should not have been on the SDCC credit card. It was done quickly when we were trying to, the volunteer was leaving, somebody's got to take this. That person happened to be there. It should not have happened that way. It should have gone on a Democratic Party credit card. It's the program itself was designed by the party, is intended to be held by the party. So that we are happy to work with. The websites are now down. We're happy to work with, excuse me, the party to move those over. In fact, they may have already been moved over. And what happened was it was literally forgotten about. It came up on, Linode charge. It was properly reported on the SDCC ethics reports, but it was not identified. I don't think they're registered to anybody. What is this paying for? That was clearly a mistake that needs to change and will change. I think then with that issue, you get down to, should there be a penalty for that? Should somebody be held accountable for it? That is obviously a policy decision for this group to make. I would just argue to you that I think there are a couple of reasons why it shouldn't. One is, it was an honest mistake. We sort of came forward and said, yep, here it is. Here's what it was for. The other is that there isn't a general exception. I know staff, I think, does not agree with this, but there is an exception in the statute for sort of office equipment, things that don't cost that person any additional money if you use it, like phones or desks or computers. And we would argue in this day and age, although it's not, articulated in the statute, that something like a hosting fee is very similar to that. They're paying $14.50, whether no candidate puts up a website or 200 candidates put up a website. The same way with a phone bill, you're paying for your phones, whether people come in and phone bank out of there or they don't. The cost does not change. So we think there is room in the statute as currently drafted to look at these as expenditures which could be exempted from reporting. That being said, we don't plan on doing this anymore. So I'm not pitching my wagon to that for the future. I'm just articulating that statute does recognize some of these expenses that don't increase with the level of use. This may be one of those things. Did that answer your question about that piece, Commissioner, before I talk about disclaimer?
It addresses it.
Okay.
I mean, I don't agree with you that the physical location, machines and things like that can be stretched as far as to include hosting services, but it's a great argument.
Thank you. Okay. I appreciate that. Great minds disagree. So we would ask, given all of that, we don't think there's any, I hope we've been transparent enough that there's really nothing else to investigate. We've kind of said, here's the situation. And given that, we would ask that you simply allow us to work with the staff to fix it and not have it happen again, related to the hosting fee. That's the most concrete piece in this. The disclaimer is a really interesting one. So I've heard a couple of comments about sort of, well, have the disclaimer list hosting fees, or I can't remember what that example was, hosting fees paid for by.
That was it, yeah.
Yeah.
It said authorized by the candidate, hosting fees paid for by SDCC.
I will say, and maybe Attorney Bolton will disagree with me, I have never advised a candidate to mess around with that disclosure statement. To me, the disclosure statement is not for you to customize. It is a not paid for, authorized by, or paid for and authorized by. So I'm not necessarily opposed to that kind of change, but I would ask you to be explicit in that, either in the commission's omnibus bill before the legislature. I would be very uncomfortable advising my clients to kind of make up their own disclaimer based on, who provided a hosting fee and who, that kind of lack of really direct guidance feels very uncomfortable to me. I also think.
Let me interrupt for a second. Shouldn't it be accurate though? Because these were not paid for by the candidates.
Yes, I think they should be accurate. I think you face an interesting question when you have some of the exceptions, like party exceptions, right? Where people are working on things that are specifically sort of exempted from being a contribution or expenditure. What concerns me about going down the path of listing the HDCC for $2 is think about how different that is from your decision in Cape Voters, where you said that somebody who paid a $2,192 invoice was not on the disclaimer because it had greater informational value for the public than naming Sandy Dunham, who merely picked up the tab. So to me, your decision in Cape Voters is completely contrary to this idea that a $2 expenditure somehow should be on the disclaimer. I think if going forward, people said, look, any amount of money you pay needs to be articulated in the disclaimer in the following way, I would be okay with it. But to me, it feels like the proposition that this disclaimer was wrong, given your decision in Cape Voters, to me is very contrary. This is a $2.02 expenditure per candidate. That was a $2,000 expenditure. And to me, the public might have wanted to know that. And I know you all discussed this. So, they might have wanted to know that Sandy Dunham was the one who paid for it. You decided that it was in the public interest and that would be a distraction. And I would just argue to you, if that was a distraction, how can $2 not be a distraction? It makes the voter think that the SDCC has somehow had an oversized involvement in the website when in fact they didn't do anything but pay the hosting fee. And I'm not denying that $2, but let me stop there.
Well, and for my purpose personally, for my own opinion, I'm not necessarily adopting the staff's recommendation to do the hosting fee paid for thing, but I do think that the attribution should be accurate. And in this case, it wasn't paid for by the candidate.
And how, Commissioner, if I may, how do you square that with the decision in Cape voters? Because you agree, the commission, not you,
Right.
I apologize. I apologize, Commissioner.
That's the group you.
That's right, it's the universal you. That's what I'm struggling with, that just happened in November.
Sure.
So how does the standard change that much?
I think we ended up with at a place where they were both accurate, where that was accurate. And I think in this case, the attribution paid for by the candidate clearly wasn't accurate. Was it?
I think
Did the candidates pay for anything with relation to that website?
they didn't, but it says paid for and authorized by the candidate.
It just said paid for by the candidate.
Pardon me, I'm not remember, there were a lot of websites, so I do apologize. Some of them had different versions of various sundry things, yeah.
Let me ask you another question.
Yeah.
The web pages had donate buttons, correct?
I'm sorry.
The web pages had donate buttons.
That
That-
I don't know, I'm not sure. I don't.
That was my understanding. Yeah, I read it in the description. And I'm wondering who the donate buttons linked back to. Or to.
I don't know.
Mr. Clardy, do you know?
When I checked out a few of them, a lot of them linked back to Act Blue, the
That's
campaign
national.
donations.
Okay.
The clean election candidates that I checked out, I think linked back to the Democratic Party or generic PAC donation.
Maine Democratic Party? Or?
I don't remember. Okay, right offhand. But like she said, lots of websites.
Yeah, sure. Oh. Commissioner Hastings, are you anxious to say something?
Well, I do want to say something, the issue to me isn't really whether it's $35 or $15 or whatever. It's the fact that maybe wittingly or unwittingly, the party created and posted and made available to the public, 79 websites for candidates, which obviously were, in my mind, intended to advocate for their election. And were left up for another cycle with incorrect notices on them. And to me, that's, as with the Republican campaign committee, when you skirt close to the edge of the law, you better do everything exactly right, or you should get burned for it, and to some extent. I mean, all these websites were all up for this 24 election cycle. Whether or not they were I guess they weren't even authorized by the candidates. So, but they said they were and paid for by them. The fact that and maybe not a lot of people looked at them, but some people would have looked at them and maybe been influenced in some way. So anyhow, to me, that's the biggest thing here. I don't care about the 15 or 35 bucks as much as I do the leaving these sites up that I believe this committee should have known existed and should have not continued without somehow reporting and recognizing them. That's where I come from. I'm not sure where that stands on violations, but I see whenever we see these committees getting close to the edge of the rules, that's sometimes what happens.
Would you like
And
to
I
address
consider
that?
it more of this certainly is not the same as paying the rent on the office. These were definitely advocacy websites.
Yeah, I'm gonna defer to Ms. Brzezinski for a minute. I just want to be clear. No one was trying to skirt the rules. The websites themselves can be put up and built by Democratic Party staff under the statutory exception that Democratic Party staff can provide 40 hours of staff time
Sure.
without it being a contribution. So I just want to be sure that people are focusing on the mistake here is the Linode hosting fee. We were not trying to skirt close to any line. We have been very transparent in our memo to the commission about what charges came in and what they were for. So it is about the hosting fee charge. It is not about the building or the launching of the website. That was all done lawfully. It's very standard practice for Democratic Party staff, so.
Sure, and I get that. Ms. Presenti.
Thank you. I was gonna reiterate some of what, Attorney Knox just said. Our investigation found that it was this staff error, you know, a clear mistake, that resulted in this Linode fee not being, I think in a better situation, it would have been reported to the candidates as we made this very small contribution to your campaign. How do you want to deal with it? That's the part that didn't happen. I think we agree that it's a thing of value. I think we can all disagree about whether it's analogous to a phone line, or a phone bank that is for advocacy purposes. But I think part of the question is, you know, for this $2 contribution that was made to those candidates, in the future, how is it reported? How is it disclosed? And in the immediate term, what's the remedy? So obviously the caucuses have taken those websites down. We have worked with them to say, you know, we're going to figure out how to report this stuff and how to move it forward. It's not that nothing went wrong. It's that what is then the next step in terms of, you know, any assessments from this commission? We felt like the staff was going in the right direction in terms of focusing on encouraging, you know, the disclosure improvements that do need to happen. But accepting that the candidates themselves were sort of out of the loop on this, unfortunately, and that's clearly a staff error. And then because of the small amount of money involved, you know, if there's a violation against SDCC, that is obviously your discretion as to what that would be. But it's, I think there's a lot of directions this could go, but I think because of the information we provided in the staff analysis so far, the staff time and how these websites came to be is on one side. The $750 contributions are on the other side. And it seems like we do have to deal with this $14.50 a month issue.
And obviously the contributions, even if they're so small to the clean election candidates, are an issue. And I, you know, just as a recommendation for the future is you can do that kind of expenditure for clean election candidates without coordinating with them.
That will not happen again. I can assure you. I'm sure. That is, yes, agreed.
Yeah. Commissioner Murphy.
Just because I can't sit here and never talk, my mouth needs to work. I remember for full disclosure, when I was a candidate for the first time with no previous experience, and luckily had a terrific and smart young team around me. And we had met and we were talking about vision for the campaign and who's going to do what and who's going to write editorials and how do you do this and who's going to knock on doors. And somewhere from the back of the car I was driving, someone says, "Oh, we need to get a domain thing." And what I'm getting to is the technology change and how rapidly they change is something confronting all of us, especially I think smaller candidates that are kind of out there. I didn't know what the hell that was. And someone said, I think it was the same person said, "Well, I'll register Marble for Senate under GoDaddy or something." And he's sitting on a phone, which I still don't own. I don't have a cell phone. Sitting in the back of the car with a credit card, picking this thing. It's only $14 or whatever. It wasn't. And everybody in the car, especially me, ignored anything after that moment. Yeah, great, next. Focusing on trying to run a campaign. I'm saying all of this mainly to say that the amount of money involved does have an effect on my thinking, just to disclose that. My biggest concern, there are two. One is how it interfaces with clean election candidates. And two is just the disclaimer is just being wrong. And I find, right or wrong, more fault with the PACs and the party on that than I do individual candidates.
Yep.
And I would not be opposed to a very modest fine reinforcing that point that we're not disputing what you're fixing. We appreciate and respect the direction this is going. But it doesn't totally work for me to simply say there was a screw up and there's really no financial consequence. It needs to be something modest. I don't know what that is.
Commissioner, if I may, I don't disagree with you that if you find fault, it should be with the PAC. I just don't think it's fair for candidates who have such distance from that's just the PAC's opinion that, we hope you don't impose a fine, but if you do, I do not disagree that it should be related. It should be to the PAC. The candidate should be.
And I agree with that as well. Yeah. Are there other comments, questions, potential motions from commissioners?
I'll just say I tend to agree with Commissioner Marble's comments.
Okay, I'll make a motion that we find that the attribution was inaccurate and that it violated 21A MRS section 1014 paragraph 1. And that the SDCC violated 21A MRS section 1014.1 with respect to the payments, and that the penalty would be $159.50 for the aggregated subscription fee. Is there a second for that?
I'll second that.
Okay. Is there a discussion? Okay, we'll go to a vote. Commissioner Leclerc,
Yes.
Commissioner Hastings,
Yes.
Commissioner Ahern,
Yes.
Commissioner Marvin.
Yes.
I'll also vote yes. Thank you all for coming in. Thank you, Mr. Clardy, for identifying this for us. Thank you guys for
Thank you very much. Appreciate all the time.
yeah. It's, I think it's worthwhile, and I think things will improve in the future.
I'm glad to never look at websites again. Yeah, right? It's a lot. Thank you very much. Appreciate it.
Thank you,
Nice to meet you.
Mr. Clardy. Thank you. Okay, moving on to agenda item 8. This is a request for a penalty waiver from Joe Boyd. Is there anybody here to discuss that?
Yes, his treasurer as well as Mr. Boyd should be on shortly.
Okay.
I'm gonna disappear for a minute. I have to plug my computer in.
Okay, we'll wait.
Could take a 2-minute break.
Sure. Let's take a break until 10:35. Actually, let's take a break until 10:40.
Nice to see you.
How are you guys? Good.
you? Me? While I? While you? While we? I was going to,
It's Sarah, but she is. There we go. Okay, we'll reconvene here. We have Mr. Boyd, and I can't read the other person who's here with us.
Mr. Wiseman.
Mr. Wiseman. Mr. Boyd and Mr. Wiseman are here. I don't know if you've seen the proceedings we've done already, but what we'll do is I'll have Mr. Wayne give us a brief background on the issue that we're addressing here. And then we'll hear from you guys. And then we'll discuss it and make a decision.
Sound like a winner.
All right. So, Mr. Wayne.
Thanks. Is Commissioner Ahern?
Oh.
She got her.
Sorry.
Oh, there she is.
Sorry, I almost ran forward without you, Commissioner Ahern.
Sorry about that. Took me a minute to get up the stairs.
No worries. All right, we're gonna hear from Mr. Wayne on this, it's item number 8.
So during the last 13 days before an election, candidates have to report larger transactions that they engage in. And a lot of states have this requirement, and the thought process is if a candidate makes expenditure of $1,000 or more in that 13-day period, it's big enough that the public and the opponents, they ought to know about it before the election. So it's not, there's sort of an accelerated report that's due within 24 hours. Mr. Boyd's campaign on October 31st made an expenditure of $2,308 for a mailing. We discovered it jointly with the candidate when we were trying to reconcile his campaign finance reporting. And so we advised him that the campaign was required to file a 24-hour report on November 1st, but it wasn't filed until December 20th. The preliminary penalty amount for the late report is $2,262.82. Both the candidate and the treasurer are here to speak in support of the waiver or answer any questions. And they explained that the candidate is very new at this. And at the time that the report was due, the treasurer had a family emergency. The commission has.
Can I speak to that?
We'll give you a chance in a minute.
And just one more sentence. The commission has been assessing penalties in the range of $300 to $350 for missing a report, filing a report late, but for good cause, the commission has gone down below that sometimes.
Okay, great.
Thank you.
Thank you. Are there questions or comments from commissioners for Mr. Wayne? Okay, Mr. Boyd, would you like to
Yes.
address us?
Yes, I'm ready to address it. Yes. Can you hear me?
Yes, we can.
Okay, well, I had some concern about this penalty that was we had to dip since I was a new candidate and I was a late candidate, So once I got the letter from the I got audited and everything, I felt violated, you know what I mean? So what I did, once I received that letter, it was a threatening letter. I said, why are we being penalized for something so minor? It's a minor violation. You know what I mean? So what I did my research, and what I did, I went and looked up that law. It's a statute, that it's a state law that they have on the books. And after I read that law, I felt like that law was unjust. It's an unjust law to me. And to me, it's unconstitutional because you're penalizing somebody for something so minor. So in other words, what I'm saying, you're turning innocent citizens into criminals. And once I read that statute, it's a Class E crime. I say, wow, why is this law is on the book? See what I mean? So I felt.
Let me stop right there. I just want you to be clear that you're not being charged with a crime here at all.
Yeah, I understand that, sir, but I'm just saying that it's a law. It's
okay.
a law. That's what I'm saying. I just say that I did my research on that. I had to do that because I'm a new candidate. I was a new candidate and I'm inexperienced. You know what I mean? And plus I was a late candidate.
Sure.
So it was a minor mistake. It was a lot going on. My treasurer, he had some family emergency. So you can't expect everybody to remember everything. It was just so minor. It was just it was a human mistake that and we've been penalized for filing a late report. So that's why I had to do my research on that, do more research on that law.
Sure.
When I read that law, and
So-
I felt sort of violent. But I'm gonna let my treasurer speak right in the moment, and he can tell you, because during that time, during October, I remembered all that, receiving Gmails from the commissions, letting me know about all these different reports that you have to file. You have to file a 24, 42, 15. Everything was going so fast. And there was so much going on during that time frame. And I was out, doing doors, so.
Well, I'd like to just speak to just
yes,
one
let my
aspect.
treasurer speak to that too, yeah. Because he has a family emergency.
Yeah, so, as Joe Boyd said, at that, it was a perfect storm, at least for me. And as far as that goes, my son, through an act of just pure luck, was on his skateboard and he fell and broke both of his arms, both. And one of them, what complicated more than just breaking both of his arms is that one of the arm breaks was on a growth plate. So I obviously had to redirect all of my efforts in trying to deal with what I was dealing with, because we didn't know what we were going to do in terms of whether surgery was going to be necessitated. So clearly the crunch of the filing deadlines and all of that, and the expenditure, came and went, because at the time that's what I was dealing with. And so there was no conscious effort on my part or anybody's part to deceive anybody or to make the Ethics Commission's job any harder than it already is. I recognize that you guys are not only dealing with us, you're dealing with a cavalcade of everybody's personal issues. Everybody's got something going on, and I recognize that. All I could say is that I acted with due diligence and as much focus and strive to file as the accurate information, recognizing that Mr. Boyd's campaign was done with public funds and not private. So that made me, more sensitive, obviously, to that. I just wanted to be clear that, the circumstances that provided itself were unique. And, I strive to do the best job that I could, and recognizing that there was a problem, and then trying to rectify the problem. I did communicate both with Mr. Boyd and numerous times with the Ethics Committee locally, as the campaign progressed. So for my part, that's kind of what happened. Obviously, it was more nuanced than that, as you can imagine. I'm sure everybody has kids. It was a pretty stressful period of time. So thankfully, we got through it, and he's okay. But at the time, there's a lot of things in the air.
Mr. Wiseman, are you driving?
No, I'm parked.
Okay, great. Thank you. I was.
I'm not gonna. No, the roads aren't very agreeable today. So no.
I agree. I was concerned for your safety, and
No.
I'm glad to hear that your son is doing better. Ms. Brzezinski,
I appreciate it.
okay.
Thank you.
I'm glad to hear that your son is doing better.
Oh, I appreciate that.
Are there questions from commissioners for Mr. Boyd or Mr. Wiseman? Questions or comments? Yes.
Just a comment. You're the second candidate or elected official this morning to, I think, understandably feel personal emotional reaction to this. And I want to assure you again, like we mentioned to the other person, this is not about anyone disparaging integrity or suspecting questionable motives or anything like that. And the second thing I'll say, which will be no help to you, is for years we see multiple people with extenuating circumstances, with power that cut out, with a personal emergency, with a treasurer in Atlanta, Georgia on business who didn't get the phone call from the candidate the previous afternoon. It's understandable the stuff happens, and I think that's spoken to clearly in the staff recommendation about reducing that formulaic penalty down. So I just want to assure you, this is not any one staff or commission suspecting you of anything other than integrity.
Okay, may I speak to that, sir?
Sure.
Yes, I was yeah, I can understand that part. That's why I was very concerned about, because when I received that, when we got audited, I would say, wow, why am I being audited for something, you know, it made me feel like a criminal, made me feel like I committed a crime when I got, as a matter of fact, I heard from Portland, I got a letter from Portland. They want to look, they need all of my bank statements. So, and what I did, I went to my bank and I got my bank statement. See, the bank statement was the most important document in my paperwork because it got everything on there. You have your withdrawal and your deposit. And I think when I received that letter, it had to say something about a surplus. I said surplus, you know, it made me feel like I embezzled some money or something. You know what I mean? So I said, well, let me do my research, and that's what I did. So I went to the bank, got my bank statement, looked at all my documents. I took all those documents to the Ethics Commission, then gave the young lady there all my paperwork, and you know, and then I went and read that statute, and then once I said, wow, why do they have a law like this on the book that penalize innocent citizens that make them, you know, you're an innocent citizen, but you could turn an innocent senator into a criminal? Because when I seen that it was a Class E crime, which is the lowest crime on the books. So that's why I felt that that law that they have on the book is an unjust law. And I'm from the South. You know, I lived through Jim Crow. And I remember when Martin Luther King was arrested for unjust laws in the state of Alabama. It was minor laws. And this law, it brought back so many memories. I say, wow, that's why I felt violated. So that's why I'm glad we having this discussion, because like I wrote in my waiver letter, I was an inexperienced candidate and I was a late candidate, and I did not receive no classroom instruction. I think you should have some classroom instruction. If you're going to give someone, a candidate, a book, I think you should have a classroom instruction to explain what's in that book, to let the candidate know the do's and the don'ts in the book, what you can do and what you cannot do. Because laws like that is unconstitutional. That's the way I look at it. That's my perspective on that law. That's what I was concerned about, that law, because I had to read it. That law is in the book. And then when I read what I think they 2% on this amount. If you late this many days, you get 2%, and made me feel like it was sort of like a tax on the citizen. And I didn't really agree with the law. That's what I was concerned about. So that's why I'm glad we having this meeting. So maybe in the future, when the next group of people that running for the state representative, like in my position, I was a new person to the candidate. I didn't get a lot of support. I didn't get no training, no classroom of training. Only thing I got was a book and say, you're on your own. And what's so great about it, I almost won. You know, the people came out and voted for me. That was unbelievable. And I'm very grateful for that, because voting is very powerful.
It is.
Voting is very powerful. And I really appreciate all the people in District 55 coming out voting for me. I was a new candidate. So that's my biggest concern was the law, and they penalizing citizens. And, you know, I don't think that should be a penalty for something so minor. That's just my take on that.
Well, thank you. We really appreciate your appearing here today and your sharing your perspective with us. One more time, I want to make it absolutely clear, though, you're not charged with a crime.
Okay, good, sir. I'm glad to hear that. I was just concerned about, because I had to read that law. It was a Class E crime. It's one of the lowest crime, and I just felt like I don't think it should be a law. It's an unjust law, the way I look at it.
You are not charged with a crime in any respect.
Okay.
Commissioner Leclerc.
Okay. All right. Thank you.
Yeah, I mean, that's a would be a distressing thing if you were charged with a crime, but I think in looking at the statute that is being used here, there's no allegation that you ignored the commission once they contacted you. You filed your report.
Yeah.
And under, I think the portion of the law that talks about the Class C crime is just somebody who is notified by the commission and then ignores it. And there's no allegation here that you did that. You complied.
Yes, I complied. Yes, I really did comply. But when you talk about unjust laws, because I know MLK talked about those unjust laws, and he said that as a citizen, you have the moral duty to disobey unjust law. Even Thomas Jefferson, make the same statement about unjust laws. You don't have to. They don't consider unjust laws. Tell you the truth.
Right.
They are unjust. Only just laws are considered laws, not unjust laws.
Right. And the law here just requires you to file reports on time. So it's not, this is not a criminal offense. It's just a case in which you didn't file a report on time.
Yep, we don't.
Yes, Commissioner Clark.
I'm just saying we don't have the authority to enforce any criminal penalties. If you were to face that wouldn't be from this body. It would be from.
Yeah, I understand. That's why I'm saying I read further, and they say that I believe you would be referred to the IG. They are the one. Yes, the IG are the one that really look into that. And if then you have to go through a court system and do all that. And for something so minor, that's what I'm concerned about. Yes. That's why when I received that letter, I felt violated. The letter appeared to be threatened. And I didn't even think we should have been ordered. The way I look at it, what the commission should have done is given me a courtesy call, and I would have got in contact with my treasurer, and me and my treasurer would have went into the office, and we could have got on the computer and got into my account, and we could have just go ahead on it and put all the information in the computer. But see, yes.
I mean, periodically during the filing, sessions, I would be in contact with ethics, because sometimes, for my part, the system wouldn't even recognize my username or password. And if I'm not mistaken, and I'm not at home, so I don't have the benefit of my log history, but Aaron would reset it for me, or even sometimes just accept that there was a problem. I mean, it was kind of strange that way, and I would use the same name and password because obviously I needed to remember it. But I mean, the Ethics Commission, for their part, always strived, in my opinion, to work with either the candidate or the representative. So I don't have any complaints with the staff personally. I think they always answered the call, and if they weren't available, they always called back. So, I mean, look, for me, this is the perfect storm. I can't state it any more plainly than that.
Sure. Well, thank you very much, gentlemen, for helping us along with this. I'll make a motion that we grant the waiver and reduce the fine to $300.
Second.
Is there discussion?
I just have one thing to add.
Yes.
Mr. Boyd, I hear what you're saying, and education, the class. I want you to know that this commission wrestles with how best to educate candidates, and there'll be ongoing discussion so that none of you are caught unaware. So I appreciate you talking about the need for education. And with that, I support the motion. Yes.
Okay, Commissioner Hastings?
Yes.
Commissioner Leclerc?
Yes.
Commissioner Marble? Yes. And I'll vote yes. So the fine is reduced to $300. We partially granted your waiver request.
All right, thank you.
You bet. Have a great day, you guys. Thank you.
Bye.
Okay, moving on to agenda item 9. This is a request for penalty waiver from Rita Edelman. Is there anybody here? You're not here for. Mr. Wayne.
I had heard word that his treasurer or her treasurer might want to participate, but
No, he changed his mind.
Okay.
Yesterday.
all right, thank you. Rita Edelman was a first-time candidate for the Maine House of Representatives in District 21. On October 30th, she made an expenditure of $1,970 for radio ads, and that required the filing of a 24-hour report on October 31st, but either due to a lack of awareness of the requirements or a communication issue, both of those reasons are cited in the waiver request letter. No 24-hour report was filed. So we notified the candidate that the preliminary penalty for the labor report is $1,851, and we received a letter from the treasurer, Mr. Mallard, seeking a waiver. And so I think they're relying on the letter and not participating in the meeting. They cite that they're novices at campaign finance reporting, and Mr. Mallard suggests that sometimes communication was slow in terms of finding out what he had to report. So in keeping with past precedent, commission staff recommends a reduction to 3.
Are there questions or comments from commission members? Okay, I'll move that we reduce the penalty to $300.
Second.
Is there discussion? Okay, Commissioner Leclerc,
Yes.
Commissioner Hastings,
Yes.
Commissioner Hearn,
Yes.
Commissioner Martin, yes, and I'll vote yes as well. Thank you, Mr. Wayne. Agenda item 10 is a proposed stakeholder group to simplify pre-election deadlines. Wouldn't that be lovely? Ms. Pazinski, are you here for this?
I am interested in it.
Okay, great, but you don't necessarily want to address anything or, okay. Mr. Wayne.
Well, this was a suggestion that the commission received at the December 18th meeting. Attorney Josh Tardy was here representing a leadership PAC that had not filed an independent expenditure report on time. And he cited, as an advocate for the different PACs and party committees that need to file reports with us, that in his view, the combination of deadlines from the 24-hour reports and the independent expenditure reports, they're just, from his point of view, confusing. I think he used the phrase bureaucratic morass. And he suggested that either the legislature or the commission might want to think about putting together a working group or stakeholder group to try to review these and see if there's any simplifications that happen. I asked if you guys want to move forward with it, and you suggested putting this on for a future meeting. So it's scheduled for today.
Very nice, thank you. What do people think? Commissioner Hearn.
I think this is a good idea. Of course, I go right to the brass tacks and want to know, Mr. Wayne, what the difference between having the commission establish this stakeholder group and having, I know with the legislature, it's expensive actually. And I don't know if there's any difference having the commission put the stakeholder group forward.
Well, honestly, I haven't had a lot of experience watching legislatively created
study committees.
Yeah, I mean, I know that there are official study committees and there are costs associated with that. I also was sort of aware generally that sometimes they put together more informal groups of stakeholders to talk about things like this, and there might not be a cost associated with that. I think it has, more of an imprimatur if, if the BLA committee is putting this together maybe than us, but they could be equally effective.
Yeah, I would anticipate that there wouldn't be any cost to this except for staff time to support it.
Staff time, and if there are any legislators on it, then there's a cost associated with that.
Only if the legislature pays it. I mean, we wouldn't be paying the legislators.
Right, but then the fiscal note gets big and then then the, the chances of it actually being funded get lower. Having
Well,
been involved in many of these stakeholder situations where,
right.
yeah,
That's if it's a legislative study, and it's a bill that's passed by the legislature to set up a study group. If we set up an informal study group, people would be volunteering their time to serve on it, and
yeah.
the only expense would be the staff time.
I think that's the way to pursue anyway. It gets complicated over in the legislature.
Yeah. Do you think that's worthwhile?
Yes,
Does anybody else think it's worthwhile?
I would agree. It is complicated. I don't know if we can uncomplicate it, but it's worth looking at.
Yep.
the amount of people who come before this commission with a request of a waiver for that 24-hour reporting, I think that in and of itself behooves more scrutiny.
You have any thoughts?
Not any great clear ones. I'm wondering if something does go forward, regardless of who organizes it. Is there any way to appropriately include a couple candidates who have come here in the group? We had one gentleman a month or two ago very clear about, he understood it and he wasn't upset. He didn't take it personally, but he was pretty cogent about pointing out why this part made sense to him and this part didn't. And I just thought the voice of the candidate might make sense in this, unless we can capture it simply by staff recall and reflection, which is fine. I'd hate to occupy anybody's time with something that was not productive or helpful. I'm a little bit like Commissioner Hastings' comment about, don't know if it will. I don't want to put words in your mouth, but you said something to the effect of, I don't know if we can uncomplicate it or, make it any more clear. But I think it is worth a review. I think it's worth taking a look.
And I think if we're going to do this, I would envision a working group that would have candidate representation, PAC representation, legislative representation. What other stakeholders? Yeah, certainly our staff.
Clean election advocates, there's the Maine Citizens for Clean Elections. Get that perspective too.
Yeah, sure. Are you?
We're game.
Yeah.
I mean, if the majority commission wants to do it, we can do this and have at least a couple of meetings and see if there's something that we want to propose and come back to you.
And I think the goal might be to propose either regulation or statute changes, if it's possible to simplify things. And I think with your generous approach to this, we'd love to have the AG's office included as well.
Sure. Yeah, happy to.
Can anybody think of any other stakeholders who ought to be included? I mean, I think we'd include you as a representative of the PACs, probably Josh Tardy, since it was his darned idea.
Mr. Chair, if I may.
Yeah.
I mean, I would say I agree with Mr. Tardy's assessment and others who have said that if there's a way to improve it,
Yeah.
it would be excellent to do, and I would be happy to help.
It would be excellent, and thank you for your generosity.
We should make Josh share it.
Can anybody think of other stakeholders or folks who ought to be involved or invited? Yes, Commissioner Leclerc.
My answer is not responsive to your question.
That's okay.
I'm talking about the scope. The last candidate that spoke, Mr. Boyd, talked about explaining, I think, basically to the candidates what the law is. And I think the commission staff has done an excellent job of putting out information. But I'm wondering if we could look at, I think he said you put out a book, you should explain the book. And I'm just wondering, this might be outside of the discussion here of the working group, but is it possible at the beginning of the campaign season to have a Zoom meeting with the candidates, or is that just too large a group to do something with, where just a session could be done where they do go through the book and say this, don't mess this up. These are the ones that we see most before the commission, these violations. So I just wanted to throw that out there. I don't know if it'd be part of the working group's recommendations or whether the commission staff could address that. Mr.
Certainly
Points.
worthwhile question, not really related to what we're doing, but that's okay.
Yeah, well, I love direction from the commission on whether you'd like that to be part of the stakeholder group. But just in terms of whether that's feasible, it's feasible to hold some sort of training electronically. We used to do more trainings, especially like pre-COVID. We even would do, in-person trainings. But a lot of the candidates, not all of them, but a lot of them are in a political party, and they're, for the caucuses will also organize their trainings. They actually like to have their own people sort of advising. So I think that was a factor in why we stopped doing in-person trainings. But with the advent of all this technology, we could. It's certainly feasible to do that. I don't know that we have that many takers, so it might not be a situation. We might only have 30 or 40 people who want to take part, unless you didn't want us to really strongly encourage it, which we could. So I think it could be done. Is the answer.
Thank you.
And I have to say, not that I've done an exact count, but it seems like the Republican Party candidates outnumber the Democrats when coming to, I didn't know, I didn't understand, I'm inexperienced. So I don't know. So I guess my question to you, Jonathan, is have the Republicans been having these trainings? Do you know?
I believe so. I mean, I know, I haven't, I don't think my information is up to date. I used to be invited to House Republican trainings, but not in the past few election cycles. I'm sure I've heard that the Senate Republicans have done trainings. I just don't know in the 2022 and 2024 what the status was.
Okay, thank you.
I think the topic is worthy of inclusion in the scope of the work. Okay.
So it sounds like we're generally in favor of this working group to try to look at the reporting requirements, particularly towards the end of the election season, and see if they can be uncomplicated. Is that true?
Yes. And if there are, yes, and if there are recommendations to change the statute or regulation, I think that's the appropriate place to do it.
Yep. Do you have that as a kind of a guidance?
Yeah, I think that's sufficient, but I'll just to double check, I'll re-listen to the video, and I think that's fine.
Okay.
Really, okay,
Okay.
got a good idea.
Okay. Do we need a vote?
You may want to take a vote just so you can tell your stakeholders that the commission has officially decided that
Sure.
they'd like to convene the stakeholder group.
Sure, okay. So I'll make a motion that we convene a stakeholder group to discuss issues about reporting towards the end of election seasons, and to try to uncomplicate them by making recommendations for statute changes or rule changes. Yes, Commissioner Leclerc.
Well, it's not ready for discussion yet, so I'll withhold. I'm
I think
sorry.
that's probably as ready for discussion as it's gonna get.
Okay, I would like to see perhaps some direction on parity between parties and kind of the professionals in the field and citizen groups. In other words, you don't, I would like to not see it dominated completely by attorneys and stuff. I'd like to have some citizens groups. I'm really not really familiar with that, if that's an appropriate request, but perhaps someone could educate me on that.
I think we want to have it be a bipartisan and nonpartisan working group that involves as many people with interests and knowledge of the subject as we can. Subject to their willingness to participate.
Okay.
I'll second your motion just to keep it alive.
All right, thank you. Is there further discussion? And so I think our direction would be to Jonathan to kind of draw up your concept of what this might look like, and maybe we can review it at the next meeting and finalize it. Make sense?
Yes, absolutely. Should we reach out to people in different categories, or is that?
I wouldn't yet. I wouldn't until we have a chance to review
Okay.
the recommendations for who ought to be on the working group and whatnot. So it's been moved and seconded that we constitute this kind of a working group. Any further discussion? Commissioner Leclerc,
Yes.
Commissioner Hastings,
Yes.
Commissioner Ahern,
Yes.
Commissioner Marble, yes, and I'll vote yes as well. Okay, so is there anything else to come before the commission? Anybody want to make a motion that's very likely to pass?
I move we adjourn.
Second. It's been moved and seconded that we adjourn. Commissioner Leclerc,
Yes.
Commissioner Hastings,
Yes.
Commissioner Ahern,
Yes.
Commissioner Marble?
Yes.
And I'll vote yes as well. Thank you all.
Thank you.
Thank you.